Hello, everyone, and welcome to Medicamentum Authentica. I'm your host, Dr. Andrew Kaufman. And tonight I'm not going to focus on natural health or germ theory or virology, but instead I'm going to have a discussion about law with someone, a very unique gentleman who I encountered his work only a month or two ago, but I've gone through his course, an advanced course. And we were able to connect and we hit it off very well. And we're both kind of pursuing similar things in parallel. And I'm speaking of the one and only Brandon Joe Williams, who has come on the scene about a little over a year ago and developed quite a big following, putting out free course material and really going on a deep dive into the law, and not just one section, but actually covering many different areas of law. So you can see his material and get kind of a comprehensive overlook of the areas that people are really researching. And Brandon also, even before he studied law, had some very interesting accomplishments. He's the author of a couple of books on marketing and relationships. And he also has extensively been a member of the Church of Scientology, done a lot of studying and really educated me on some of the true nature of what's going on in that church. And of course, it's not what everybody thinks on the surface. So I'm very pleased to welcome Brandon Joe Williams.
Hello, hello. Thank you.
My pleasure.
And for your show, just to be clear, it sounds to me possibly like your show has a lot of medical professionals or professional type people. So my platform is definitely very, very wild and silly. I do have a couple of URLs that we can use instead of the main URL. I have don'tbeaslave.com and I have brandonjoewilliams.com, but there definitely should be a bit of a disclaimer. I will definitely not be acting that way on this show, but just a little disclaimer. My platform is pretty, shall we say, oh gosh, how would we even describe my platform?
I don't know. You use sort of a lot of adolescent male humor
Yes,
to
yes, yes,
attract,
yes, yes.
the right audience.
I'm trying very hard to take just as a background, because I want to clear this up. I don't want people to be, oh, what the heck is this guy? I'm trying to take the subject of law, which I am a marketing demographic person. That's what my entire history is: marketing demographics. A lot of demographic research, surveys, literally going on the street with pens and clipboards for thousands and thousands of hours. This is my background. And I wanted to take the subject of deep dive law, which, as I progressed through my own studies, I realized the average age of the individual interested in that was either a 70-year-old white person or a 25-year-old black man. Literally, that was like pretty much the entire demographic interested, and it was either the 70-year-old white person was trying to change the way they see America going in the wrong direction, and the younger black man was because he was in trouble with something with litigation, and he was trying to figure it out very, very earnestly. And I decided to myself that I wanted to expand that demographic, and I wanted to try to push this information into a much lower demographic. I've gotten that demographic down to probably around early 30s. I've been able to stretch out that demographic all the way down to, I'd say, about 32 is probably, I mean, we definitely get some teenagers and some 20-year-olds, but it's really not. But I've like solidly, like seriously stretched the demographic all the way down to about 32 years old. So for me, my platform, the entire purpose of that was to stretch out that demographic, of which I have done successfully, but it is extremely wild. It's like a Jerry Springer show.
Well, I mean, to be honest, right? People generally don't want to sit down and read law books. It's pretty dry material,
Yeah.
right? So
Yeah.
now, of course, there is the attraction of, being able to really have all the freedom that you deserve as a natural man. And there is the attraction also of, the financial aspects, right? You call it infinite money. But there has to, like, still, even if we said, oh, you could get $1 million if you read this, law dictionary cover to
Yeah.
cover, I don't think too many people would do it. So I think it's great using that technique. And, because a lot of folks just need a lightness about it to enter that. And, like,
Yes. Oh
for
gosh, yes.
example, when I saw you and Joe Lustica have that chemistry and the extreme sarcasm, right? It's like, it just gives a casual context that you can talk about this and actually, have fun. Like, tonight we're going to talk about a lawsuit that I'm in. And, I'm not freaking out every day about having to, go into court and present my case or anything like that. It happens very slowly. You have a lot of time, to prepare and do everything. And, it's kind of a fun opportunity, actually.
Oh yeah. Yeah. Yeah, yeah. I mean, to your point, I am trying very hard to invite. I'm trying basically my whole goal, what I'm trying to do is I'm trying to kind of nail that center demographic, which is where it's people who aren't completely like, I guess you could say, like TikTok. It's a little bit, it's too much for me. I just can't do it. I don't want to do it. But I want to get like halfway to that point where it's like the people who don't really want to read, but what happens is they come across such uh um catalytic video or audio format content that it blasts them into a motivational level where they are tearing through books. I feel like it's I am the gasoline's already there, especially with the environment, the way things are in the country right now. The gasoline's already there. I just want to be that spark. And I feel like I've done a really good job of being a Jerry Springer show in a way where I create that spark, and then that it creates that person to want to, okay, I'm willing to read now. Do you see? And I'm very good at that. I will say I think I've done a really good job of that specifically.
Well, I mean, that's the most important thing because we're really, we're getting at inspiration. And, that's really the only thing we can do from platforms like this, right? Is inspire people to take their own action by setting an example, by, using whatever devices are at our disposal. So, I
Yeah,
commend you for having such a large reach in such a short time. It really
yeah,
shows that, there is a strong desire out there, and hopefully we'll provide some further enriching content the rest of this discussion.
love it.
So, should I kind of set things up, or do you want to talk about any more general things?
It's up to you. You are a lot more aware of your demographic than I am. Whatever you think would be best.
Well, I'm not really sure who is going to be interested in this. I think it's going to reach perhaps, definitely in my audience, people are interested. And I do talk about this on my platforms, on my private platforms, but this is a little bit broader. And I've really been, Brandon, looking at all of the people out in this space. I mean, I'm sure I haven't identified everyone, but there are quite a number of folks talking about all kinds of issues related to, for example, consumer credit, different types of loan-related transactions and credit cards, a lot of things about passports, driver's license, status as a U.S. citizen, and all this material. And many of the processes that people teach, right? They always say that, you may not be successful, so you have to be ready to sue or to be sued at some point. But there's not a lot of folks that seem to have experience actually going through the litigation or teaching about specific strategies. And I know this is an area that you're getting into in your focus as well. So um, that's why I thought this would be a good discussion to have, because what occurred is that I was following some process using negotiable instruments that were sent to me, by a credit card bank, and sending them in a way that I think is an appropriate way to pay. And I think the starting point we have to realize is that in our entire banking and financial system since 1933, there's no real money in terms of something of tangible value like gold and silver coin, which, in the Constitution, Section 1, Article 10, right, is the money or the official legal tender of the United States government. But through the emergency legislation in 1933, that was taken out of the system. And since that time, all we have is paper. There's no real thing of value. And once you understand exactly what that paper is based on and how it's created, you realize that you can't pay in any way, meaningful way, with anything of value. All you can do is move this paper around the system according to the rules. And so we are trying as a community, right, to learn the rules of how this works and what our place is. And we don't all have exact right answers yet. And partly taking action in the courts is going to help us learn those answers, because the judgment that will occur will tell us what, if we're right or if we're not right.
Yes.
So there is some risk involved. And so by taking action like this and trying to, use this paper in the appropriate way, I ended up getting sued by the bank. And I'm not going to give the names of the parties right now, because if I don't have to sign a non-disclosure agreement in the future, I'm going to release everything publicly, because it'll be on the public record. And so I was served, with papers and had to figure out how to respond. And it's still early on, but I did write a response with all my defense strategies, counterclaims included. So we can talk a little bit about that. And I'll tell you what. Yeah,
Can I
go
say
ahead.
a couple things here? Because
Yeah, please do.
A lot of things here. I'd like to just cover a couple things here. So first and foremost, just to be clear, for a long, long time, I was trying to get compliance and I was trying to get enforcement in other ways besides litigation, because I am like everyone else. I am not some fucking superhero that people think I am. I'm the pickle man. You know what I mean? That's my people think I'm a superhero, but I'm really not. I try to be as transparent as I can, because I want people to realize that I have the human experience no different than they do. I went through tremendous, tremendous fear and terror and sleepless nights and difficulties with friends and being removed from all sorts of things that I care about very much. So it's one of those things where I, you know, it's been a long road. I've been able to get us up to maybe 15 to 20% of the time we're able to get some sort of headway with these various activities. But there's absolutely no pattern to it at all whatsoever. It's just like just shooting completely in the dark. One person may get wonderful results. You do the exact same thing. You send it to the exact same place with all the exact same paperwork, done with the exact same pen. You could send the freaking pen in the mail. And this exact same thing, the stickers for the parcel, it could be the same cardboard for the freaking everything could be exactly the same. You could do molecule searches and you know what I mean? You could go and you just never know what you're going to get. It's just a dice. You're rolling the dice, right? So after a long time of avoiding litigation and not wanting to get into it and finding it to be a very what would you call it? Intimidating thing. I just really for a long, long time. And then finally I started to realize that it's kind of like the only path left. I went from writing crazy, weird things to drawing pictures to sending in Polaroids of me in silly outfits. I have a bunch of silly outfits and onesies. I mean, I was doing it all. I was doing phone calls. I was doing faxes. I was doing, and I just realized that, I realized a lot of things during that time period, including the way in which I'm going to go about the litigation is very different than anybody's ever seen before. So there are a lot of good things that have come out of that, but it was just a realization that the way that the system looks at it is you're just kind of like a little barking dog, a little barking chihuahua until you litigate. And then once you litigate, you're taken seriously as an adult. It's basically like you're a child until you prove that you're an adult, and you prove that you're an adult when you can properly present yourself in a court of law. That's just really, and people can complain and bitch and moan and freak out about that. And I just, I was never complaining about that. I just didn't want to do it until I realized that there's really not any other option. And if I really want to nail this thing down, I'm going to have to become extremely proficient in this. So I started studying day and night, and I have been studying quite a lot for quite some time before I decided to kind of dip my feet in. We just filed our first suit just a few days ago. It's not even. It's not. They just received it at the court. So there's a bunch that I'm going to be doing on my own, and then I'm doing some for some of my clients. I feel very confident in what I can do in the court system. I do not feel confident in the procedural aspect of the way that the court moves. I'm starting to feel more confident because I study and I study and I study and I'm very adamant about clearing up all of the definitions of all of the words, which is very, very important to me. And so I am learning pretty rapidly, and I will be learning more rapidly as we move through the court system. And I'm realizing that every lawyer that I come in contact with, I am literally stepping into the courtroom for the first time, but I'm already 400 stories above every other lawyer I come into contact with. And that's something that I mentioned to you on the phone, is that myself and you think in the same way. We think that we need to be 10-star warriors before we enter the battle, right? And we're willing to put in the work, even if that requires many, many thousands of hours to do so. What's happening is when we're arriving on the battlefield and realizing that everybody else in the battlefield is a 1-star, we would have been fine as a 3-star, but we're a 10-star. And I think that is the one of the most important things for people to realize, because it's a lot less intimidating than you think. The intimidation is an illusion. It is entirely an illusion. It is a bunch of children with cardboard shields, and they're just kind of in diapers, and they poop their pants, and they're just running around. And that's been my experience so far, including a lot of the pro se people that I have had the pleasure to speak to. So it is a very interesting field, because I very much, very, very strongly want to create some sort of pro se litigant course and give it away for free, describing all of this, describing the mindset, describing the procedure, describing, kind of everything the same way I did the contract killer course. That's in the near future of what I want to do. So just to give a background on that, I am just now very, very seriously entering into the litigation atmosphere.
Yeah, well, we both are, very similar in our thoughts about this, and I was not rushing into it either. In fact, I feel myself fortunate now, but the other party took action and sued me, so that kind of, I didn't have a choice.
Yeah.
Right, it's time to go. And I definitely agree that the the profession of attorneys, right, which is different from what we're talking about here, because they learn law from really a procedural aspect,
Yeah.
right, civil procedure, whereas they don't necessarily study the body of law to the same degree that we do. So they're going to be largely ignorant of what we're talking about. Now, even some of the judges, and I already experienced this in the past when I was an expert witness in mental health, and we had cases before the court all the time, and the judges didn't know the precedent cases in that area, even though they were regularly assigned these cases. They didn't like even take the time to learn it, and sometimes we had to educate the judge about these matters, right? So you may possibly be in that position. The one thing I would say though is that you have to be able to understand what you're doing and back it up. So, for example, if you walk into a courthouse or a county clerk's office to file documents, right? And like I had this happen to me. Now, I will tell you that I'm actually um, wrote my paperwork and filed it as agent for my all caps name as the defendant,
Yeah.
right? So
Yeah. That's good.
I'm not that person. because that's an abstract, corporate entity or trust. And in order to file the affidavit of service, so you have to guarantee that when you file documents in a court case, they actually get to all the parties, and there are special paperwork to certify that you actually sent it to them and that they actually received it. And so this affidavit of service is that document, and the defendant, quote unquote, is not allowed to certify that affidavit, right? Because it's a conflict of interest. However, when I went to affirm that document, they said, "Oh, you can't. You're the defendant." And I said, "No, I'm not the defendant. I'm the agent for the defendant as principal." And I said, "I have a power of attorney document to back that up if you'd like to see it." And that's all I needed to say. And then he's like, "Oh, no problem, sir." And then he notarized it and then he filed it. Right. So all I had to do was just understand what I was doing and what the basis, and have another, either I could refer to a statute or I could refer to a document that was the evidence needed to back up that claim. And if you are prepared to that level, that's what you need to be. You don't have to know every law, right? You can always ask for a recess to prepare your response to something. Everything moves very, very slowly. Right. In my case, there's been 3 documents submitted, 2 from the plaintiff and 1 from me, and there's not even a judge assigned yet. So, and the original filing was in September, and now we're in January, right? So you have plenty of time to deal with these things. Nothing is, immediate and nerve wrenching. And I think the chance of actually having to go into court and testify is pretty low, although I would
with
relish
these
that
with these
opportunity.
subjects. Oh yeah, I've known a lot of people. I've talked to a lot of people, and I've never heard of anything even close to a courtroom. I mean, even close to a courtroom.
Right. Well, I think the only way you're really going to go there is if you file in small claims court. And that actually may be a worthwhile tactic for some cases where the amount is, low enough to do that. Because
Yeah,
there you can just basically tell the judge what's going on. And if you explain it properly, you may very well be successful.
yeah, yeah. It's exciting.
So in this case, we have the credit card bank filing suit. And interestingly, on the top of their summons, it says consumer credit transaction, right? And so, for example, if you go to file in federal court, there'll be a form to submit your complaint. And on there, it'll ask you which section of the law is relevant to your suit. And one of those choices is consumer credit.
Hmm.
So, right, this is definitely an area where there's commonly litigation occurring. And then here's an interesting thing, that if you get sued by a so-called creditor, that the law tries to favor them, and by, if you're scared and you don't do anything about it, they get what's called a default judgment. So they write this on all the papers, of course, but they say, you have 30 days or 60 days or 20 days, whatever it is, to respond. And if not, right, basically the judge will say, guilty. So just respond. Even if your response is, I need more time, that they'll give you more time. But don't, shoot yourself in the foot by just giving away the money. So now the cause of action here that they sued for is kind of interesting. So they mentioned a couple of things. So one is,
Do you want to talk about what that means, cause of action at all?
yeah, yes, yes. So the cause of action is the actual basis for the lawsuit, right? So if you are going to initiate a lawsuit, right, you have to have a cause of action. Like it could be, for example, breach of contract. Because if you're talking about litigation in finance, right, there's always a relationship. There's a bank, or creditor and a borrower, or a loaner and a borrower. So in that case, the cause of action could be related to a breach of contract, because there's always a contract between the borrower and the lender. But there are other causes of action. But this is also that in the law itself, if you search these different causes of action, and this may vary by state or federal jurisdiction, that there might be specific criteria to meet the burden of proof for that cause of action. Now, with breach of contract, that's kind of wide, and contract law is pervasive, and it's a massive subject, and it's definitely something. I would say that you need to understand contract law and trust law to at least a basic level of proficiency to really be able to handle these matters in terms of litigation.
Yeah.
But it's not; those are not very complicated. They're just probably, and contracts, are something that we enter into all the time. They may not be on paper, and actually, the law says that they don't have to be expressed on paper.
Yeah.
Um, right. So anytime, Brandon, gosh, like I would love to talk to you. Will you do my show, and then I'll give you a copy of it to put on your channel? Right. We just made a contract right there, as long as
Yeah.
he agrees.
Yeah, and like if you're, let's say, even if you're driving a car, you have a duty. The way the law looks at it, you have a duty to make sure you're not running people over with your car, right? Even that is sort of like it's not quite looked at as a contract, but it almost kind of is, because it's sort of like by driving that car, there is sort of like this unspoken contract that you have a duty not to run people over on the
That's
crosswalk,
right.
right? So the cause of action for being run over by the crosswalk is that there was a duty. That duty was breached. I mean, it wouldn't come up as a breach of contract necessarily on the actual paper, but everything, like you're saying, it's true. Everything that you're doing is some sort of contract. Every time you communicate with someone, every time you purchase something, every time you uh, speak to someone. I mean, even speaking to someone and increasing or decreasing their emotional tone in a way could be considered some sort of emotional exchange, contractual emotional exchange. That's getting a bit esoteric, but I'm just trying to point out that really everything, literally everything. I mean, breathing is a contract if you really want to get down to it. Anything that exchanges anything between anything, pretty much.
Yeah. So breathing is what, a contract between you and the air.
Well, you could say it as a contract that you're converting uh, oxygen into carbon dioxide, and you're exchanging that carbon dioxide with trees, whatever.
Yeah, so that's good. It's a contract with the plants because you give them CO2, they give you back oxygen, right?
Exactly. Yeah.
That's a really good one, and
Yeah.
it also helps people understand the hoax of climate change.
Yes. Oh God. Yes. That's a big one. Yeah.
So they listed two causes of action on this. Well, actually, yes, first and second. Now, the first one is kind of interesting because it's essentially breach of contract. They say that, I violated the card member agreement by failing to make periodic payments as required. Right now, here, it's the definition of payment that perhaps is a key issue to understand how they could make
Yes.
that claim.
Yes.
But in order to establish themselves as upholding their end of the bargain of that agreement, they first say that I applied and received a credit account, which they own, which is true. They own the account. And that they are the original creditor. Now, this is where I believe fraud comes in,
Hmm.
because the original creditor means that they are the source of the assets that are lent or provided as credit.
Yes.
Okay, so that's the first cause of action, right? So, as original creditor, they fulfilled their contractual duties and obligations, but as a card member, I did not because I failed to make payments. Now, the second cause of action is kind of interesting, and it's really defensive on their part, where they basically say that they sent me periodic statements and that I did not object to them. Okay. And what that really means is that there was no dispute on the account because, according to federal law, if the account is under dispute, they are not allowed to pursue collection services. And this lawsuit would be considered a collection services, right? In fact,
Mm.
on the top of their complaint, they say I believe they say this is an attempt to collect a debt.
Mm-hmm.
So they wouldn't be allowed to do that if it was in dispute. So they're pretty much saying this defensively: oh, you didn't dispute these bills, therefore we have a right to sue you. But that's not the case either, actually.
Yeah.
I just didn't dispute it in perhaps the way that they recommended on the back of their billing statements.
Yeah. Well, they don't, we have we have hundreds and hundreds, if not thousands of people doing all this stuff right now. They don't get it. We had one just today. I mean, every single day I see something new, right? From Bridgecrest. I think it's a mortgage. I could be wrong. I think it's a mortgage. And they say right on the response that they do not accept promissory notes. And I just fell out of my chair. I was laughing so hard.
That would
Uh,
void the mortgage because the mortgage mentions a negotiable instrument right in it.
well, Federal Reserve notes are promissory notes. So they
That's
literally
true
just
as
told you
well.
they will not be accepting Federal Reserve notes. So now you get to a point now where you say, well, how you want gold and silver coins? What do you want? You know what I mean? I can't pay you anymore. You're saying I cannot physically pay you, which is so funny because UCC3 is very clear that you cannot refuse any negotiable instrument payment, which would be, any type of promissory note, any sort of a promise to pay, any sort of written signed promise to pay, any sort of bill of exchange, which would be an order to pay. They cannot actually deny these things. And actually, there's a section of UCC3 that states that once you even offer these things to them, they, even if they do reject it or do not accept it, then whatever amount that you offered, which is called a tender, whatever amount that you tendered or offered is actually instantaneously removed off of the account as though it's a payment, even if the so-called payment is rejected. So it's actually
That's
very,
right.
very funny.
It simply has to be made in good faith.
So all these letters, there's all these letters that are being sent out. So many letters. I see letters every single day. And they always say the same thing. They say, blah, blah, blah. You sent this thing in. It's not real. We don't accept this kind of payment. You still owe us, blah, 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 blah. It's pretty much that's the communication every single time. We're starting to see now a little bit more detail. The Bridgecrest one and a couple other ones I've seen, they go even farther and they say we do not accept any special or restrictive endorsements such as, and they go on to say paid in full. They go on to say negotiable instruments. They'll say that right in the letter. Some letters I've never seen that before. They're starting to get more specific, which is all still completely false information. But I do find it interesting that we're starting to see a little bit more detail in these letters.
Well, that is quite interesting. And, I mean, this is an area that's very important to bring up. I mean, we weren't necessarily going to talk about discovery, but there's something called interrogatories where you can submit a list of questions to the other party, basically to, get at evidence of how they're going to
Yes.
address those issues. And so asking some simple questions because
Oh, yes.
so for example, I've seen in court testimony one time, and I think this might have been a small claims court, where the judge asked it was a plaintiff who was suing in this case, I believe, or maybe they were the defendant also, actually. Did you pay in US dollars? Now, this is quite interesting because all the negotiable instruments that we're talking about, they're all denominated in US dollars, right? In fact, the coupon on your monthly credit card bill, right, it has a dollar sign right on it. So there's really no difference between any of these things. They accept checks, right? So you can't say a check is a dollar bill Federal Reserve note, but it's US dollars because that's what it's denominated in, right? It's not a foreign currency. So any of these instruments, they're all equivalent. They're all denominated. You're not going to write, to pay in yuan on there or rupees.
You
It's
could though. You could
always
though,
US.
and they have to accept it. Actually,
But
you could
well,
because those
you
are all
may be
negotiable
able.
instruments as well.
they may charge a fee for exchange, but
Yeah.
nevertheless, right? But this guy got nervous when the judge asked him this, and he said no. And then, boom! Right after that, it was like case over. You didn't pay in U.S. dollars, right? Now he didn't say, well, I only had some kroners, and so
So
I
hold
sent
on a second.
those
You're
in,
saying
right?
the defendant was asked that question,
Yeah.
and then the defendant said no.
The defendant was the one who tried to use an instrument to pay. I think he
That's too
was
bad.
paying
That's
it.
too bad because
It
he did
was.
pay in U.S. dollars. Because
I know.
the definition of U.S. dollars is very, very simple. It's one of two things or both, because you could technically use both as a payment for U.S. dollars. It's either a bill of exchange, which is defined as an unconditional order to pay, or it's a promissory note, which is defined as an unconditional promise to pay. Federal Reserve notes are promissory notes. Every currency pretty much is some sort of promissory note. There's only a few countries left that have real currency. So the thing
Right.
is
Well,
that you could send in any promissory note. You can even manufacture promissory notes. And by definition, that would be a payment for US dollars. And the exact reference on that would be 18 USC 8, which is obligations or other securities of the United States, where they're very clear that all promissory notes, bank notes, bills of exchange are all obligations or other securities of the United States.
right. So, this is a very good point. And let me just break it down in simple as possible for people that all of the things that we think of are money are all negotiable instruments.
Yes.
And there's two kinds of negotiable instruments, right? There's, as Brandon called it, bills of exchange. And we generally don't use that term as much in the United States anymore. It's generally referred to as for foreign negotiable instruments. But drafts is another word that you could use, and that is an unconditional order to pay. And the other kind are notes or promissory notes. They mean the same thing.
Mm-hmm.
And that's an unconditional promise to pay. So
Mm-hmm.
you have an order to pay and a promise to pay,
It's
right?
that
So
simple.
when
That
we have
simple.
a dollar bill, a Federal Reserve note, that is a note. So it's a promise to pay. And a check, and we write a check, that is a type of draft or related to a bill of exchange, and that is an order to pay. And we're actually ordering the bank who holds the account to pay the payee, whoever that is.
Yeah, so bills that you receive in the mail, such as a bill that you receive from your utility company, it's called a bill. And whenever you see the word bill or billing department, that is a shortening for the full term called bill of exchange. Those statements or those bills or the reason why they are called bills is because they are unconditional orders to pay
That's
a
right.
fixed amount with or without interest. It says pay $57 by January 21st. That right there is an unconditional promise to pay. That actual bill that you receive at the end of the month is actually, you could actually convert that bill and send it in. You could take a bill from your telephone company, you can write some things on it, and you can mail it to your water company, and it's actually a payment for US dollars. That's how
Well,
insane that's how
right
insane the
now,
system that we have
but
is.
Brandon, let's just give an example like that people know from their everyday life of how you can do this because we've all written checks, right? So
Yes.
checks is a negotiable instrument that you can write on, right? You can write in the memo section. You have your endorsement on the back,
Mm-hmm.
and you can actually, if someone writes a check to you, you can actually write instructions on there to another party,
Yes.
right? So there's all kinds of things that you can do. You just never kind of were given this rule book. And here's
They
the
don't
issue.
want you to have it.
That's
It's
right.
the
And
it's the
when
biggest thing. It's the biggest thing on the entire planet that they don't want you to have. I mean, I know you guys talk about a lot of things and the medical stuff and all this stuff. This what we're talking about right now on the top 10 list of things they do not want you to have. This is probably number one on all their lists.
That's right. So these bills of exchange that they send you every month, right? Notice they have the positive balance on there. And here's where the confusion comes from, right? You think they're ordering you to pay them, but it may be that actually a different party is ordering a different party to pay. And so that's what we have to figure out. It's with in order to pay, there's three parties. So we have to figure out, who's in each role and where do we fit in. And then we can properly write the correct instructions on that. And basically it becomes a check,
Yeah.
right? Which I say use that term because it's familiar to you. It may be, a demand draft or technically a slightly different thing, but essentially it's a check. And even if you look at those coupons on the bottom, they have a string of numbers on the bottom, and the leftmost number is 9 digits, right? Which is a routing number. Now, if you try to
Yeah.
look that up under bank routing numbers, you won't find it because it's a private routing number.
Yeah.
And then you'll find after that the account number, and also in there is often the amount of the minimum payment, right? Just like on a certified check. So that really contains all the elements of the check. And you can find this written about in the federal law under the Treasury regulations. So you can look for Treasury Circular 300, which is the prior version, but it's an extensive document that you can find for download. And also in the CFR, the Code of Federal Regulations, if you look up the area around restrictive endorsement,
Mhm.
you'll find they give you instructions of how you can give different instructions on these bills. And
Mhm.
they'll also describe what the coupon is and give instructions about tearing it off or not tearing it off and about endorsing it. So you can, actually find these things in the law. We're not just making this up and hoping that it's a check. It's right in there. What we just may not know is the exact best way how to write these instructions and exactly who is the best individual to send it to process it. And that's where we're running into the kind of problems that
Compliance and
Brandon
enforcement.
described.
Mhm.
Right. So for example, I sent the instruments myself to several parties, but primarily to the chief financial officer of the bank. But I also sent a copy to the regular billing department, and also on the bill itself, they list some additional numbers that you could send in certain circumstances. So I sent it to all those places. So that way, there's redundancy, and maybe someone might know, what to do with it, although they didn't really know. But they never refused any of these instruments. They didn't send it back and ask for something different. They really mostly ignored it. They did send correspondence asking for another power of attorney from a separate department within the bank.
That's interesting. I've never seen that. Interesting. Okay.
And then they did send me notice that they closed my account. So I
That's
couldn't
pretty common. Yeah.
continue using the card. And ultimately, they sent me a charge off notice, which is basically what they do is on their accounting books, they write off the debt. So their books are balanced and it doesn't show up as a loss or liability. However, they still pursue collection. So even after doing that, that's when they decided to sue me to collect, what they think are unpaid debt.
Yeah, and then just to give my same situation, same story. I did American Express for $177,000. I had on two cards, business cards, like multiple businesses, and we kind of racked it up, and then I around
But
90,000.
these were under your personal Social Security credit, not on a business credit, right?
Yeah, and we were at about 90,000, and I said, you know what, F it. I'm gonna just crank this thing up as high as I can go. I went on a shopping spree. I had a blast. I furnished my whole apartment, bought a brand new TV. I bought all this great stuff, computer parts and car parts and all sorts of good stuff, desks, and I think even the camera I'm on right now I bought during that. And then also running a business and running a couple businesses and all sorts of good stuff. We got it up to about 177,000, and then I went for it. I said, this is it. I'm gonna go for it. I was very scared. I sent them. This was a long time ago. I didn't know a lot about a lot of this stuff, and I just sent them this freaking 25-page freaking storybook. It was like something out of it was like a combination of a story, combination of of a philosophy text, combination of a love letter, combination of a hate letter. It was just this like craziness, and it had this whole thing about how I'm trying so hard to learn all this, and I'm going out there and I'm helping to rekindle America and rekindle the original America, and I want American Express to be a part of it, and I'm willing to actually help American Express be the premier creditor of the new world. And I was just like went off, right?
Right. This reminds me of the Jerry Maguire memo,
Yeah, is that right?
the
I
one that
don't think
got
I've
him
ever even seen
fired,
that.
right?
Yeah,
Oh, sorry. Yeah, that was the main story, right? He was working at this fancy sport, coaching thing where they had all the premier clients, and he writes this memo, and it's very inspirational, like about we could
yeah.
make this a great industry and such like that. And then they all basically said, "Get out of here, you're fired."
That's basically what I did. I didn't know any better. I was more of a writer than a litigator. So I went through my writing eyes, you know what I mean? And I was like, okay, I'm going to impact them through my writing, right? And I just go on and on and on about, and it's all in my course. I have the whole video breaking down this particular document. Now I look back and I kind of chuckle a little bit, but it was all part of the learning experience. I have no regrets. And then below that, I talk about the different statutes and the different things that were violated and that kind of thing. And I say, there's going to be liens that I'll be filing if this is not complied with. But I was also very jokey and very light. But then at the same time, a couple of snippy parts in there. I try to keep it not this heavy, nasty, threatening thing. So they sent me to Altran Collections, and then they did hire an attorney, a law office. The law office sent me a letter. I sent that was the first letter I had sent. Then it went to collections. Then it went to the attorney. And then I wrote up a whole nother thing that I sent to all the credit agencies, to Altran, and then also the lawyer. And then after I sent that second letter, everybody dropped everything. And the lawyer actually sent me a letter, and I posted that letter on my website. And that letter says, hey, we've decided we're not admitting anything guilt. We're not admitting that we've done anything illegal, or we're not admitting that Altran's done anything illegal. But Altran has made the business decision to not pursue this debt, and we're also not going to report it. And I have that actual physical evidence of that letter posted on my website, on the course sign up page. If you scroll all the way down, you'll see that letter. So I've never, of all the crazy things I've done, that was the closest I ever got to litigation, and it never happened. So, but it's kind of like, to your point, it's sort of like, well, had it happened back then, I probably would be a star litigator now, because
Right.
I would have been thrown into the middle of the ocean, and I would have had to swim my way all the way to the shore. And honestly, there's almost a part of me wishes they would have sued me. I would have been
Brandon, I
learning.
had a very similar experience that I was doing a slightly different process based on equity, using the acceptance process for my property taxes on my prior home. I still have it now, but basically I began doing this, and then they basically sent me all these letters threatening tax foreclosure. And then one of the assistant finance commissioner sent me this letter. She said, "Stop sending all of these notices of acceptance and dishonor." And you could tell from this letter that she didn't understand. Like, she did never looked it up in the law that this is a real thing. I think she thought I was just some guy making stuff up. So I decided it was
Yeah.
the wrong people to talk to. They're the tax collectors, but they don't understand anything about the law. So I found the county attorney who was in charge of property tax for the county. And then I found out who in the state gets involved with this. So I sent it to the state tax commissioner, a copy, and then also to the comptroller of currency for the state, who they regulate financial matters and financial institutions. And I sent a notice of default, and I went through like all of the law, including tender of payment, by the way, which is a very powerful
Yeah.
section of the law in these cases. And once I sent that off, I got no reply at all, but I have not received any correspondence from them whatsoever related to any delinquent tax bills or liability. So they just sent me the regular like bill for this year, but it didn't have any delinquent taxes on it. So that is sort of not an outright victory where they kind of admitted that okay, your taxes are paid. However, they're not pursuing trying to steal my house, so and send me harassing letters. So I consider that victorious for sure.
Yeah, totally.
So I think one of the things to understand when you are dealing with this is exactly what your role is. So I look at my name in all capital letters as not exactly my name. That's an entity, right? Perhaps even owned by someone else like the government, but that's not the flesh and blood me, because we don't write our names that way. And I think everybody who's looked into this space kind of has heard about the straw man concept. So in signing and writing instructions on these negotiable instruments, I did it as agent. Right now, agent is someone who has basically responsibility for entering into contracts for a principal in a trust, and for doing basically like accounting and those kinds of duties. And the principal duty is actually to notify the principal of any notice that gets sent to the agent, because they are like the liaison. Now, they're different from a trustee, because a trustee is the one who has the fiduciary duties of the trust. So, in other words, paying the bills and such. In fact, a lawsuit is really the trustee's responsibility. But we can sort of talk about that separately. But by delineating clearly to the court that I am the agent and not the principal, not the defendant, because this lawsuit is against the all caps name, it's not against me, the man. And that's what one of the ways to delineate that is to say that you're there by special appearance, and that means only to argue the matters of law and that you have no personal liability. And this is actually delineated in New York law, so I was able to reference that. But if now, in order to actually be like accepted by the judge as the agent, there might be some further things that you have to do. So one possible way is if you have a power of attorney that is upheld, but also there's a process called ratification. But I just want you to know that if you're an agent and you get ratified, which is something you can definitely achieve. In fact, I think that when I was allowed to file that affidavit of service as agent, that actually ratifies me. Um,
Oh,
but
interesting.
but nevertheless, if you're ratified, that means you have no liability whatsoever. So, in other words, even if you lose the case, the judge will look to the trustee, another party, to pay the damages, not you, because you're the agent, so you're not the responsible party. So, this, in other words, gives you immunity, so to speak.
That's right.
Right. And this is just similar to the concept. And, many people think that this is valid if you go back to the congressional record of 1933, that all the property is actually owned by the government and that we are the beneficial, you could say the beneficial owners or the beneficial users of the property, right? So the property is for our pleasure, and we are supposed to be good custodians, right, by taking care of it, and preserving it for the future, but technically it's not ours. And some evidence of this may be where eminent domain, for example, where the government can come in and renovate, take your property for their own use. They do compensate you for the inconvenience, right? But it's not the same way you'd be compensated if you owned it. You would be able to prevent it in some way, right? But we don't have to get into the technical details, but just understand that if this is a way for you to remove yourself 1 degree from the case, to protect yourself if you're able to do it successfully.
Yeah.
So that being said, what I did was, so I had to answer to these claims with defenses. Okay, so now, let me just preface this by saying first that, like you, Brandon, I didn't know much about the actual court procedure, like what paperwork do you have to file, that thing like the affidavit of service. I didn't know about. I knew there was service, but I didn't know that there was that kind of a document that needed to be filed, right? So, what I did as soon as I got served with the papers there is that there were some different phone numbers there on there for the local county courthouse, and I just called them up and I said, how can I, get some help with the procedures? Now, of course, they're not going to tell you about legal strategies in the law like we're talking about tonight, but they sent me to the law library for the county, and I called them up and they said, "Oh, let's make you an appointment." I went in there. There were three librarians. They weren't busy that day, I guess, that sat down with me, and they had already prepared, actually, and they handed me like templates for different responses that I could follow one template or the other. They asked me about if I was using any affirmative defenses. They gave me a document about affirmative defenses, right?
Wow.
They asked me about counterclaims, right? They were super helpful, and they told me exactly what papers to file and such. They even told me stuff that I didn't even technically have to do, right? And they answered all my questions. And I'm going to, continue to go back and get further information from them as the case goes on. They're an excellent resource. It's almost like they're your free paralegals. I mean, they're not going to fill out documents for you, but you say, "Oh, could you find some information on this?" They'll go find it and then give it to you. So and they really like doing this, especially if you're someone who is a nice, generally speaking, and not an asshole.
I'm just laughing because I'm just thinking in the back of my head a little plug for any lonely men out there who maybe have some failures with online dating. Go meet your local
Well,
librarian. They
yeah,
want to
they
get some feminine energy in your life. You know what I'm saying?
there was only one man in the library. They were all women. That's
There you
that's
go.
absolutely
See,
true.
see, there you go. We got you. We got you here. You know.
Yes, Brandon. This is the male demographic, right? You always have to look for that angle.
Yep. Yep. Yep.
So what I did is, because what I'm saying, really, right? They're saying I violated the contract by not paying, but I did, right? I sent in lots of paperwork, actually way more than you would if you just sent a check each month. Because what I did was, I sent the instrument, right, that bill of exchange we were talking about, with a cover letter with instructions.
Mm-hmm.
And the first time I did this, I also sent a power of attorney.
Mm-hmm.
And then when they didn't respond, I sent them a notice of dishonor, right? Because non-payment is dishonor, and their part involved in paying, actually, right? So they're eligible for dishonor, and that's in UCC Article 3 as well. And and in after several months of this, I actually went to the length of filing a formal protest, which is also known as a certificate of dishonor, where a notary actually reviews the evidence that I sent them these instruments in good faith, and I then sent them a notice of dishonor, and they still didn't respond. And so that they are now officially in dishonor, adjudicated by a notary. And this is part of your notarial protest duties, which is required in every state's notary laws. And then I sent a copy of that to the Secretary of State, who is the boss of all the notaries for your state. They're like the head notary. So that's a legal document, right? That's admissible as evidence. So I actually, right, sent them quite a lot of correspondence, and it includes my noticing them that they're not actually doing what they're supposed to do, right, which is a type of dispute. So instead of a normal defense, right, where you kind of say, well, yes, I did that, but here's why it's justified, right? So, for example, if I called them up and said, "Hey, I'm going to be, on a expedition to Antarctica for the next 6 months, and I won't be able to pay my bills. Can you please send me a bill when I get back?" and then they sue you while you're gone saying you didn't pay your bills, right? I could defend that saying, hey, we had an agreement that I was going to be out of the country, right? But in this case, I actually did send in payments. So I would use what's called an affirmative defense, basically saying, I actually did that, but you guys are cheating in some way, right? And the what I chose to use to help with that is fraud. Okay, so essentially they're committing fraud by stating that there's this debt that I owe to them, when in fact I have more than adequately fulfilled my performance obligation to satisfy that debt.
And it gets even more exciting than that too. Just to chime in for 2 seconds.
Please.
Every time you use your credit card, you are promising to pay. It says right on the receipt that prints out. Every single time, every single credit transaction. If you think about if you want to go even crazier, see, it's so unrealistic to people. Everything is money. You are surrounded by money. I was on my group the other day, and I said to somebody, I said, you are Scuba Steve. You really are Scuba Steve, because you got to think about this. Every time you use your debit card, you are in that transaction. A debit card is essentially the same as an e-check. A debit card transaction is an unconditional order to move funds, right? A credit card transaction is an unconditional promise to pay funds.
Right.
So what's crazy is that every single transaction that you're doing, there's some sort of negotiable instrument that's either being manufactured or being transferred or being used in order to create that transaction.
That's right.
So you are the author of money, and you are fucking drowning in money. There is so much money in your life. Every single bill that you get is a positive number. Every single bill can be converted. All that positive value can be used. Every single credit card transaction, every single time you use your credit card, you're producing a promise to pay. When you sign that promise to pay.
Brandon, I'd like to, because this can be a little confusing. I want to break down the credit card transactions.
Sure.
So that anyone who's listening to this, you can go look at these documents and see exactly how this flows. So
I'm going to step right over here for just a moment, get a drink, and I'm going to be listening the whole time. Okay.
All right, great. So I'll take the empty space off camera and talk about this for a minute. So first you have your card member agreement, right? Which is your contract with the bank who's owns the account of your credit card. Now, in all these card member agreements, you'll find a section called Promise to Pay. And this is where it essentially states that, I promise to pay all charges for all transactions, for goods, services, etc. It might be worded slightly differently in each card member agreement. Okay, so you sign and execute that card member agreement in order to actually receive the card and begin using the account. Now, what happens when you make a credit card purchase? Okay, now if you remember back in the day, you always had to physically sign a piece of paper when you use your credit card for a purchase. Now they have various electronics in the card that actually provides your signature electronically for you. And you actually agreed to that in the card members agreement as well. But if you can still sign these receipts, and sometimes you might have the occasion. So just take a look at what it actually says. Now, occasionally it does use the word promise, but most commonly, because I've studied these over the past months, it says I authorize this charge or this transaction, and many times it references the card member agreement in the language below the signature line. And so what this is it's referencing the promise to pay section. So it doesn't have to use the word promise on the document because it's on the master promissory agreement, right? Which is that card member agreement is really a master promissory note. And then each of these receipts is the actual promissory note with the amount on it, right? Because the card member agreement has no amount. And for a promissory note to be valid, it has to have an amount of money that's promised to be paid, including interest, right? And so that's on these little receipts. So those are your promissory notes. So what happens is when those get back to the bank, we want to know how the funds actually move around, right? Now, most people think what happens is that the bank in their account, right, has a big fund, and that each time you do a credit card charge, they take money out of that fund and pay the merchant where you're shopping, or the restaurant where you just had dinner. But that's not how it works at all. And how it works is written about in the Federal Reserve Act, Section 16, and look at the first two paragraphs of that section of the law. So, Brandon, I was just kind of told them the whole thing
Mhm.
about the
I heard
promissory
everything.
notes. Oh, okay,
Mhm.
great. Now, if you look in paragraph 2, we'll just focus there for a second, right? It says that any member bank, that's a member of the Federal Reserve, but I believe that banks who aren't members actually work with member banks to do this for them.
I
That
believe personally that the all caps name is a member bank, but that's a theory.
Yeah, well,
Anyways,
that's interesting, and I even heard someone say that the all caps name is on the board of governors of the Federal Reserve.
well, think about this. Think about this, and I don't want to lose the audience, but gosh, I love this conversation. Think about this. If your all capital letter name is producing currency all the time, every time you use a credit transaction, every time you place that credit card in that machine, or tap it on a machine, or tap it on a gas station, you're producing a brand new currency out of thin air. Didn't exist a second ago, and now it does. It's called a promissory note. If your ens legis, which is the Latin term for the legal fiction all caps name straight out of the dictionary, um, if your ens legis is not a bank, how is that currency being produced? It has to be a bank. Otherwise, this is like massively, massively illegal. And if you look inside of a lot of the definitions of bank or banking or banker, a lot of it has to do with credit transactions, creating credit transactions, being involved in credit transactions. Almost every definition of bank or banking or banker I've ever seen, if the ens legis is, it's almost like it's the chicken or the egg too. It's kind of like, well, hold on. Was it a bank and that's why it can produce currency? Or because it's producing currency, it is a bank? But I'm telling you, it's one or the other. It has to be by process of elimination. There's nothing to even talk about. There's no argument. There
Right.
can't be
Well,
an argument.
yeah, I mean, Brandon, if you look in UCC, I think it's Article 9, it gives the definition of a bank, right, which is a person doing banking,
Exactly.
right? And so
That's what
now,
so
you
so
you
people
can
always
look at the
think, was
definition
it a
of
bank?
banking.
Was it a bank before you put the credit card in the credit card machine, or was it a bank after? You know what I mean? But I'm telling you, it's one, or it was either a bank before and that's why it produces, or because it produces, it is now. It's one or the other. It has to be. It has to be. There's
So
no.
what Brandon is talking about here is, as I was about to get to in that Federal Reserve Act, right? What the bank can do is that they can go to the Federal Reserve, right? They sometimes call this the Federal Reserve window, or their Federal Reserve agent that represents that bank from their regional Federal Reserve. And they basically apply to the Federal Reserve to get Federal Reserve notes. And with the application, they have to submit essentially a whole list of things, but they're really negotiable instruments. So it's a bill, a draft, a promise, a note, a bill,
It's all the same stuff. Yep.
right, all those things,
An unconditional
hold
order to pay or an
certificates.
unconditional promise to pay. There's a bunch of different things, but all those various things fit into one of those two categories. Always.
That's right.
It's just one of those two, and it's so confusing when you say all the different things. So I'm starting to kind of go more towards teaching it. Just it's either an unconditional promise to pay or an unconditional order to pay, and all those things and all the things they list and all these crazy banking terms, and it either fits into one or the other every single time. You know what I mean?
That's right. And essentially, it could be a draft or a note, whatever it is, any of those instruments that they basically can take that instrument and trade it in for the exact amount of Federal Reserve notes as is on that instrument. And that instrument gets its power from our signatures,
Hmm.
right, as agent for our principals. And so the bank is actually using the note, right, that you signed, right, and they're cashing that in and then giving you back your own money
Yep.
and then asking you to pay them that amount a second time.
It's like madness on top of madness on top of, it's just like 3 or 4 layers of complete madness. And it's when you start to, in my own opinion, I'm starting to get a lot of clarity in the litigation, right? Because the litigation is literally this simple for every single financial transaction, from what I can tell so far, is when you understand how all this works, it's very easy to develop some questions in your mind that you may have some curiosity as to what the hell happened, right? All you do is you write up a complaint, which is pretty simple. You can look up a YouTube video on that. I will be producing a lot of material on this, by the way. You wait for the other party to answer the complaint, and then you immediately motion the court, which means you write up an order to move the court. That's how the court system works. Is it's like a football field. You're trying to get down the football field to the various yard lines, and you're going to go into what's called discovery. Now, once you go into discovery, you can start asking these questions. Now, these questions, when you actually understand how all this stuff works, these questions make them very uncomfortable. And the more questions that you ask, just literally, you're just like, I mean, I don't even recommend that you go online and find my questions. What I want to do is I'm going to be teaching people how to really be curious about this and how to develop their own questions. Because when you're really curious and you really have questions, what happened to my original promissory note? What did you guys do? When was it taken to the
Right.
Federal Reserve? Subpoena the Federal Reserve. Get them to prove you guys swapped this. When did you swap it? Let me see the papers. I want to see it. By that point, they are sweating, man. They are sweating and they are running, right? So when you understand all of this, that's why we said earlier this stuff never goes to trial, because if you get into discovery, all you're gonna do is just like a kid in a candy store, like asking daddy, what's this? And daddy, what's this? What's this? Daddy, what's that's it. That's all you have to do, literally. And you will win. I've never heard of anyone doing that not winning ever, ever.
So
And I've seen so many examples where they do a very poor job of it. The questions are poor, the sentences are poor, the grammar is poor, everything is poor. They don't really have a good grasp, but they kind of sort of in the dark go in this direction and do this, and they win every single time. They settle immediately. They don't want, just please make it stop. You know what I mean? That's kind of their reaction. So what's so fascinating about this conversation is it's kind of a lot farther than what anyone's really talking about right now in this space. You're not going to find hardly anyone talking about this anywhere.
that's right. We're breaking ground, and
Yeah,
what
it's big
what
time.
you what you just described in the way to ask questions. That's kind of like the country lawyer tactic,
Yes.
right? Where you
Yeah.
basically like pretend that you're totally ignorant
Mhm.
about what's going on, and you're like you're a member of the jury, so to speak, right?
Yes.
And or a country bumpkin, and just say, well, okay, so I come into the bank and I fill out an application for a loan, right? What do you do with that application? And just take it very slow like that, right? And it's very, every single step you want to know. And that's how you're going to get to the bottom of this. And I also want to, talk about, well, what evidence do you request? Because I showed this to you in private, Brandon, but in a separate matter related to a mortgagee, I asked for a bookkeeping entry that shows what I specifically asked for was show that the loan funds were a pre-existing asset of the bank, and then demonstrate that those loan funds were transferred into my account,
Hmm.
right, giving me the loan. Now, they couldn't do either, but they did send me the bookkeeping entry showing the
Oh,
loan
yes.
from their account, from the bank's general fund. They called it, I think. And this was fascinating because there were not one, but there were two entries, right? There was a deposit and a withdrawal, a credit and a debit, an asset and a liability simultaneously. And what this was, right, was they took my promissory note, went to the Federal Reserve window, or you can also exchange it at the Treasury in different ways. But they did this. They got the funds, right, that were generated by my signature on the note. I essentially gave them an instrument worth that much funds. So they got that's the deposit that went into their account. Then they took those funds and they transferred them out. Now, they didn't put them in my account. They gave them to a third party, actually, which I didn't authorize, but that's kind of a separate matter for that case. But here, right, the exact evidence. So I could go and say, hey, how could you give me a loan if you have no net liability on your books?
Yeah.
You're neutral, right? And then
That would
by
violate the actual fabric of a contract itself, which states that there has to be equal
exactly,
consideration to have a contract. Yeah.
exactly,
Yeah.
right, and
There's a lot here. We're kind of, I have a feeling we're kind of killing off your audience here, but it's good. I mean, this is all so true. And for people who, there's a lot of really advanced stuff that we're talking about. And I just want to, I think that a lot of people might be kind of lost or kind of in and out on this one. But it just kind of is what it is. We can definitely have additional conversations on this, but this is,
right.
there's a lot of, this is going to be probably better for my audience, to be honest with you.
Well,
My
listen,
audience is going to go ballistic over this one.
so Brandon, let's simplify it because we're really talking
Yeah.
about two aspects here, right? One is we're saying, right, there is no real money.
Yes.
So we're going to use the paper that you send us and try to figure out the proper way to work within the system, right? And we're
Yeah.
saying
In
you're not
19,
honoring that the way
yeah.
that you're obligated to do.
Yeah. In 1933, they took away the gold and silver coins, which the Constitution says is the only way to pay. In exchange, they gave us all infinite credit. Nowadays, circa 2024, quote, infinite credit, end quote, or US dollars, quote, end quote, are defined as two things. They're defined as an unconditional order to pay or an unconditional promise to pay. Both of those things are called negotiable instruments. The word instrument means document or contract. The word negotiable means transferable. That's basically literally the entire thing in a nutshell. It's so simple when explained that way that people are like, it can't be, this can't be. There's a lot of emotional rejection. I'm seriously, and I went through it, and everyone goes through it. And it's okay. I understand that. That's the most difficult part of all of this now, I feel like, because when I explain it to people, I know I'm on the right track when what I get back is a completely emotional response. I'm like, okay, good. That's good. Because that means the information, the factual information was understood and it triggered an emotional defensive response, right? So it's like, am I getting a negative reaction on the information side, or am I getting a negative reaction on the emotional side, right? Now, the emotional side, that rejection can be overcome by grounding the information and letting them know, how does this benefit you? Once they understand,
Right.
once a person understands the benefits, then what happens is they allow the emotional blockage to release, because the thing is that the emotional blockage is there because of, I've been this dumb for this long. I've been wrong my whole life. I've been working so hard for these stupid fucking things, and now I'm just an idiot. But once you say, no, don't worry about all that. Everyone's in the same boat. Don't worry about all that. It's all fine. You're fine. This is the benefit that's going to happen to your life if you just drop those emotional barriers and move forward and try to understand this stuff and move forward into trying to do this stuff. To me, that's been the most successful avenue, and I'm able to get people just over the factual bar, and then over the emotional bar like that, right? And that's how I do it. I do it by grounding the information and saying, this is what you can do with this information. For example, every bill, every promissory note, everything, you can go out and buy a car right now, taking the information from this video that we've explained so far, which is a little bit convoluted, a little bit all over the place, but it's okay. It's our first time talking together. And you, by the way, for my audience, I don't think I've ever seen documentation as well as I've seen Dr. Kaufman's information. I mean, it's the complaint that you sent me was I mean, 10 stars. I mean, and it's 10 stars just objectively. Like subjectively in relation to everything else I see, it's a trillion stars. But just taking all that out and just non-relative, just straight up, like it's 10 stars. It's 10 stars. It's so far beyond anything that no one is going to be able to comprehend what you've written. It's just way too far above the anybody that you're going to come in contact with. It's so and that's the problem that I have is that I'll show you my complaint later privately. Mine is like dumb. Mine is like kindergarten. It's like so the way a complaint is written, we can get back into this a little bit if you don't mind.
Yeah,
The way a complaint is written is very, very simple. People think, and I thought too, this is what I thought when your first document, when you first file, I thought it had to have everything in the kitchen sink. You gotta have it. You gotta collect it all together. It's gotta be a book. It's gotta be, it's not like that at all because the word allege. So a complaint, that first document you're going to file in a lawsuit is called allegations. Now the definition of allege or allegation is the key to everything. It's setting forth that of which the person intends to prove. You're not proving it right now. What you're doing is you're saying, I have evidence over here. This is all the stuff that I intend on proving. And then you send that and they have to answer that. And then you start to bring in the evidence and you start to prove everything. And this is the way that the court system, so you can get these things rolling like boom, boom,
right.
you can do a complaint and you can send it in. And then you're already over here organizing your evidence. You're not even done with that yet. You're just like, boom, it's out. They have to, okay. And now you're over here getting your evidence together. So it can go fast. I thought at first I had to have the whole planet in order. I thought I had to align all the stars before I could file a complaint, right? So, and my complaint is very simple. My complaint is like, we had a contract. Some of the items in this particular interaction are negotiable instruments. Negotiable instruments are defined as blank. This document is an unconditional promise to pay. This document was written. This document was signed. Next document. This document is an unconditional order to pay. This document, next line, this document was signed. Next line, this document was written. Literally. That's the way my complaint is. It's like, can we agree? This is what the definition of a promissory note is. And it has 3 different elements. And then I say, okay, this document has this element, and this element. And that's the whole complaint, all the way down the entire complaint. That's all it is. There's really nothing else in it. I made it so dumb that it was like a 5-year-old could look at it and be like, you're screwed, man. There's no way around this one,
No, listen, right? Brevity is the soul of wit. So if you can use concision to craft your document, it's definitely going to be helpful. And the reason why you couldn't possibly make all your arguments in the complaint because you're going to obtain evidence through the course of discovery, and you don't know what you can prove, right? So what you want to do is add things that you think you're not sure you could prove, but you might be able to, because later on, if you don't prove them, they just get dropped. But if you don't mention it, they won't let you bring new arguments on at some point or new causes of action, right? So, but you could just put them in a list. You don't need to give all the reasoning, just very, very bare bones. So even this complaint, right, that was served to me, it's only 2 pages.
Yeah, and I think
there's an exhibit attached.
This is a lot of the information that I like to, and this is all the information that's going to go into my pro se litigant course, because I'm trying to break the illusionary spell that litigation is akin to climbing Mount Everest with no rations and no friends by yourself, which is pretty much what people think it is, including myself. I thought that as well. And it's not even, it's like stepping on an anthill. But it all comes down to perception. Perception is reality, obviously, right? So I like to talk about things and to give information that breaks that illusionary reality. And the illusionary, the true piece of information is you can just, I mean, kind of slap this thing together. As long as you believe you can put together coherent information in the next 30 to 60 days, you can just kind of slap this thing together. I mean, you could just type up something in 5 freaking minutes and send it into the court.
Now, Brandon, this complaint and summons that you filed, was it for a similar situation where you paid with negotiable instruments or a conditional acceptance or?
No, this one is pretty wild. So it's a real estate deal where there's all these purchase agreements and there's all these, and I'm claiming all of them as negotiable instruments, and I'm rescinding all of the blank negotiation on all of them, and I'm forcing a realty company to convert all of them at the Federal Reserve window into Federal Reserve notes and deposit them into an escrow account. So I'm going like a
All
pretty
right, that's
high.
you're going
I'm
for the gold right away.
I'm going for the this thing fell on my plate. It's a client of mine at the I have a law firm, a law office. It's something that kind of fell in my lap. The lawyers on the defense side kind of pissed me off, and the client was just ready to go, very level headed, very well educated, and I just said, you know what, F it, I'm going for it, and I just this is our first lawsuit, it's okay. It is a bit complicated, but it's okay. I feel 100% ready for it. If not, actually, I feel like I've not regrettably, but I feel like I've been a little bit pussyfooted. I should have done this a while ago, not on a regret form, but I'm ready. I feel super ready for this, so I'm going for it.
Well, look, I don't think it's ever a bad idea to delay things and do a little bit more preparation,
No, I know.
especially for
Yeah.
the people we're talking to here, right? Like, for example, if this is and I was assuming that most of the people who would view this already know a lot of this and maybe have even done some of these processes to pay bills, but have never gone to court. But don't start sending paperwork to creditors until you understand what you're doing.
Oh yes, I
So
say that all the time.
if you've done it already, you should understand what we are talking about in terms of the legal arguments, even though the stuff that we're talking about litigation, is a different matter.
I
So
the way I look at it, just real quick on that, because I think this is such an important thing to talk about. My personal communication on this is I've never been 100% when I take action. I've been like 80 to 85% confident. And I feel like it's just a ratio. You know what I mean? Like for me, 80 to 85%, I know that I'm going to unlock that remaining 20% when I take action. So it's like I hit 80% logically, and then emotionally I know that the remaining 20% I need to move forward to get the
right.
remaining 20%, right? And I think there's a lot of people who they're at 20% and they take action and then they crash and burn and they splatter all over the street. And then you have the 100% people who never, ever, ever take action because they're waiting for something that will never happen. So I think for every single individual, there's some middle ground. There's a ratio where the logical information is at a peak point. It's the emotional understanding that I feel like you're just simply not going to hit that until you force yourself to move through the wall of fire and do what needs to be done. And that it's the emotional side that will correct and clarify as you gain that confidence through action. And for me, that ratio is around 80 or 85%. So I think in my head, am I 80%? If I am, I just take action. It's like a policy for me. I just take action at around 80%, period. If I'm not at 80%, I just don't. It's like a completely unthinking, totally logical a flag in the ground. It's like, no matter what, if I'm below 80, I'm like, nah. If I'm above 80, it's action time, period. That's how I do it.
And you could say that a threshold would be just if you can explain it to another individual who's unfamiliar with this area of the law, right, and get them to understand it, then you definitely know it well enough to do the process.
That's a good point. That's a very good point.
And it may not be well enough to, you may brush up on it to go into court, right? But that's I think a good standard. Like you did that show with the gentleman who was successful with a credit card, and I'm
Yeah,
not sure what happened to him since, right? But he was
that
a
was a
great
dice roll, and
example.
we got a six. You know what I mean? We hit the that was. But
So
yes,
he
yes,
he was a great example because, right, he definitely knew the material well enough to write his own very simple instruction letter, right? And well, I think we were both impressed by the how to the point that was,
it
right?
was
It
like
was
one
it was
sentence,
it
and
was enough to get the job done.
even when they called him, it was like a 2 minute phone call, and his
Yes.
instructions was like one sentence. Yeah, I think that definitely contributed to, because in this space, everyone's sending letters to the chief financial officer or the indentured trustee or this person, that person, or God or who else. This dude just sent it into the billing department, which is like unheard of. You
Well,
know,
now
with
I've sent everything to the billing department, but I've sent it to multiple parties.
yeah, he
So
just did the billing department
well,
only.
he made up a department. Remember, he put something like remittance department, but they didn't have one. Like, but he just put that on the envelope,
Oh, I
and
don't
he used
remember that. That's
the
hilarious.
address from the normal billing thing. Yeah. So, but like if you're able to do that, like you don't need to follow a template. You can write your own cover letter, right? Even if it's not perfect, I'd say that's also a good bar, right?
Oh
And we
yeah,
should and it's good to have other people's templates, especially when they're good, because we can't always think of everything, right? And we might look at that and say, oh, I want to utilize that phrase or that sentence, but we shouldn't be just copying everything word for word and using
yeah.
everything like that, right? We need to, if we understand this, we can write it, or we might get a template from someone else and say, you know what, I'm not sure this part's correct. I'm gonna look it up and I'm gonna correct it, right? And because you can never guarantee that what anyone else has done is going to be successful, is accurate, right? Unless you have checked everything yourself, or you've created it yourself. So it's very tempting to like see the potential here and just grab something and run with it. But that's where you're going to later on have a moment of fear and regret, most likely. So just understand it at a basic level of competency, that you could talk about it, that you could write a simple, and we're talking about less than a one-page letter here. So this is not like Brandon's 24-page document that he sent to American Express. We
It
don't
was all
need that,
part.
right?
I laugh a little bit in slight embarrassment, I guess, but it's just all part of the learning process for me. I'm not really embarrassed. I just look back, and it's just kind of humorous in my opinion. But yeah,
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 absolutely.
you don't need to write a short story. You don't need to write a micro novel, which I did. Seriously.
But what we really have here, right, in this system is just, it's all it is paper moving around, right? You sign a paper, you give it to the bank, they give it to another bank, that they give them paper back, they give you different paper, right? And all of that paper, the value that we perceive, it's really ironic because we feel that we have to go out and give our time and our energy and our work, right, to get those notes in order to live. But we never stop and say, where do those notes really come from? Right? We might assume that they're backed by gold, or that, some bank just has the authority to at will print them and create them. But it's actually us. We are the ones who create all that value, right? It all comes from us signing one of those pieces of paper. Then that paper becomes the value, and they can just trade it for any form that they want. They could trade it for another promissory note. They could trade it for a check or a draft. They could trade it for Federal Reserve notes. They could trade it for securities, like ownership securities, right? Stocks, bonds, and all of these things go on, right? But the one source of all of that, right, comes from us and the energy from our signature. So really, and I know this is a tall order to accept, right? But we have been cheated. Now, it doesn't mean you shouldn't work, right? Because we have to be productive in our life, and even to fulfill the duties of generating this paper, it still is work, right? We have to, if we do it really responsibly, we have to do accounting for it, right? We have to answer all notices and communicate that information appropriately and such. And that is our labor, right? And for the fruits of that, we're entitled to live with the benefits. So I'm not saying that you should resent that you have been productive in your life. It's just that you didn't realize the value that you bring to the table. And so now you can take this information and change the equation
Mm-hmm.
so that you, right, because we're all meant to live in abundance.
Mm-hmm.
It's just that we have been treated as children, and children get allowances. They can't be trusted to have all the resources, right? They have trust funds for rich kids, so they don't go and blow all the money, right? Because it's supposed to last the rest of their life. And we are essentially have all been in this system, been treated like children that we cannot be trusted. So we're given these allowances and we're told to do the chores, right? Which is our 9 to 5 jobs.
Mm-hmm.
But so once we understand this and come out of it and rise up to be competent adults, well, now we can take the responsibility to manage the resources ourselves. And that means that we get access to the full resources, which, as you say, are practically infinite.
Yeah. I mean, I say infinite money on all my stuff just because that's literally like a video game term.
Well,
I'm
it
not. I'm
really
not
is,
kidding. That's
right?
why I. That's why I say it. That's exactly why I
But
say it. It's just a. You know.
but it is really the real life monopoly, right?
Yeah.
Because we have that, right? There are the rules, right? That we can't, in our incompetent state, we can't exchange our promissory notes directly for Federal Reserve notes, right? We need to go and beg the banker to, do it for us because they're our trustee in that matter or our fiduciary. And that means they have certain responsibilities to us, right? But we can't do it on our own in these rules until we demonstrate competency. And then perhaps if we ask, we'll actually be given access to do it directly ourselves.
Yeah. Yeah. It's a whole experience of self discovery, and it's a people want to go to school for 4, 5, 6, 7, 8 years and then come out and then build a career, which takes several years. This is basically kind of the same idea, but it's compounded into maybe 2 years. It's basically your 2 year school all the way through career building option that costs nothing up front, and it takes about 2 years, I'd say, at this point in time, which is a lot less than it ever has been because of all the resources available. We've never
Well,
ever
I would
had.
say 2 years if you really do it full time during those 2 years.
Oh yeah, of course. I mean, if you, but I'm saying if you were to focus on it as much as you'd focus on, let's say, a college degree.
Right. Or I would say more like a master's degree or even law school because, law school is 3 years, right? And they don't even touch on this material.
Yeah. So something like along that same idea is what it's going to take to get yourself into a position where everything is money. Literally everything is money. I'm not even kidding. You create money with your fingertips. Your pens create money. Everything anyone sends you is money. That's basically the life that I live. And the problem is getting anyone else to realize that everything is money, and then I'm sending money, and then I'm creating money. That's the part that I'm having a hard time with. And that's the part where litigation comes in. And that's why I'm learning litigation, essentially.
That's right. Because, even if you, not because I've done quite a bit of this since I've learned this law, is that I've looked at financial pundits and experts and I don't even go to, CNN or Fox News or the Wall Street Journal. I'm looking more in the alternative financial, gurus who have large platforms, on the usual places like YouTube. And they give quite, detailed commentary, but you can find a lot of them talking about how the banking system and finance works. And, they have these, there's sort of like the lay understanding, which is, that the banks actually have their own money and they lend it to you and you pay them back, right? And
Yes.
everybody in banking knows that's not what's going on. But what they think is that it's all about fractional reserve lending and that the banks
Yeah.
have money, but they can lend out way more than they have, right? But that's not wrong either. And there are very, very few. You can find one or two of them in interviews here and there that will actually explain how the banking system, like what we're talking about today, what we talked about before about how they just create the money based on our promissory note when we apply for a loan, right? So but because only a few, even elite bankers really
Yeah.
understand this, or at least they're
Yeah.
willing to talk about it on an interview, right? That's why it's an uphill battle. But if we, like in my lawsuit, for example, right? If it goes to discovery where I get to depose people on their side, right? Because the chief financial officer for the bank is a party to the lawsuit because I sent the bills to that individual.
Mhm.
So that means I could, if necessary, subpoena that individual to come or me go to them for a deposition to answer questions in this case because they're the party in the case and they sued me. So of course I have the right to cross-examine my accuser. Now,
Which is their literal.
well, I'm
Well,
sure
I want to say
I'm
worst
sure they won't allow
nightmare.
it.
I want to say worst nightmare, but I frankly, with the amount of research I've done so far, I'm not even sure what the CFO knows.
Well, it doesn't matter because one thing is, the CFO of one of the major banks in the United States to have to sit and spend hours giving testimony for a $5,000 lawsuit. Like,
Oh no, 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 that's never gonna
I don't
happen.
think the
But
company will
yeah,
will let that fly in the first place, right?
yeah,
But getting beyond that, like even if he doesn't know, then he would have to claim ignorance about the very basic mechanics of banking, which
yeah,
he's in charge of all of the financial operations. So that would make him look quite bad. And then I would be able to say, okay, well, who in your company does know the answer to these questions so that I could depose them? Or do you have, written
yeah,
policies that discuss this? Who's your, Federal
yeah.
Reserve agent that you deal with?
Yeah,
And
these
by
are
the way, I did
these are
look
questions.
into.
These are what you just said right there. That's the most deadly. I mean, that is just. I mean, they would rather have you take a knife and jam it in their chest. They would rather they'd be like, if they had to choose between a knife in the chest and those questions you just asked, give me the knife. Give
So
me
that's just the thing.
if it's a full metal jacket 9 millimeter round, it's probably going to be less painful than the questions that Dr. Kaufman just asked. So give me the nine
Yeah,
millimeter
these
round to the
are these
chest.
are hollow point questions, Brandon.
Yeah, yeah,
They're
yeah.
really these are 300 Win Mag questions. So,
Yeah. Yes, they really are. They really are. And when you
right.
realize that it's just that simple, man. You start getting the right questions and you're
So
just
there's a,
curious, you
there's
know?
a case, I believe it was in Minnesota, and it was a jury trial. But the judge was a justice of the peace. And later, this case was vacated by the state Supreme Court. But you can still find it. I forget the name of it. But basically, what happened is that this whole thing was exposed that it was a lawyer who defaulted on his mortgage, and there was a foreclosure proceeding. And at trial, this lawyer put the president of the bank up on the stand and basically got him to answer all these questions that I just described about, that he never got a loan. And the jury unanimously ruled, in favor of this guy who was being foreclosed upon, right? But you could tell from reading about this case that everyone was so afraid of this ruling being upheld that they found some technicality to overrule it and get rid of it so it could never be used as case law for another case. It can only be sort of talked about, right? But you see the effect that it had on the jury, because as soon as a jury of your peers, right? And I'm going to definitely demand that this be a jury trial. right?
Mm-hmm.
Most of these cases would not. They would be just have the judge decide. But no, no, no. I mean, I want the jury to be able to find out how the banking system is fraud,
Mm-hmm.
right? So they would, if I was able to get this testimony and, have this trial play out, it would be in the public record, right? That means
Mm-hmm.
I could call up, all the news media the next day and say, hey, you know what the CFO of, the largest, one of the largest banks in the nation said at trial, here's the transcript, you
Yeah.
know? Right?
No,
I mean, it's
exactly.
on the record. It's not, I didn't make anything up. They can quote it directly, right?
Yeah.
And that'll be a juicy story that somebody is going to pick up. Maybe it'll be a local news channel because, the bigger ones may be told not to report on that, right? But they don't want to take a chance.
Yeah.
And so if I can demonstrate that I can ask the right questions and elicit this information and also ask for the evidentiary record, like that bookkeeping entry, for example, which could also be called an audit trail, and correlate those things, it's like they would be taking such a huge public relations risk, right? Because what if it comes out in court, right, that they don't lend anybody any money?
Yeah.
What do you think all the other cardholders are going to do? I'm not paying them anymore.
Yeah.
you
Exactly.
know, not the normal way
Yeah.
anymore.
Yeah. Yeah.
So they would, I think most likely want to settle with me. But I actually have a little strategy in place as a fail-safe for that, because let's say that they sue me and I write a response and it's really strong and they look at it and they realize, oh, we didn't really want to put all this work in for a $5,000, debt. So we'll just dismiss the case. We'll drop it. We'll let him off the hook. Well, they can't do that with me because I filed counterclaims.
Yeah.
So, right, a counterclaim means, not only are you suing me and it's not really the merits aren't there, but actually you're in the wrong and I'm going to countersue you.
Yeah.
Right? So now they can't dismiss it because they have to answer to those counterclaims, right? So the only way they could get out of it is by negotiating and offering me something to dismiss the counterclaims.
Exactly.
So
That's one
that's
thing I've
an
been talking
important
about
way
for
to
my
trap them.
people. Yeah. It's so important. You always want to go on the offensive as quickly as possible. That's what I've been talking about to all my people in the past week or two. If you're ever sued, you want to get a counterclaim in immediately. Everyone in this space of legal and law and negotiable instruments and all this stuff that we're talking about, my whole platform, everybody on it, everybody in every single group is so worried about defense. Defense, defense, defense. I'm being sued. I'm being sued. I got pulled over. Everyone needs to understand that you want to turn you being the defendant into you being the plaintiff as rapidly as possible, and you want to go on the offensive and you want to counterattack as rapidly as possible. If you can be the first one to attack and you can be the plaintiff before you are the defendant, it's always better. You always want to, and the thing is, when you realize how much fraud is here and every single one of these things, all this stuff is so rife with fraud, you can turn around and come at them with 10 times, a million times as much ammunition and power, and you should instantly. If anything, most people, I recommend you try to become the plaintiff before they sue you. Even if they threaten to sue you, you sue them first. If not, then you do a counterclaim immediately. You go straight on the offensive. You're going straight at their
Right.
throat.
So
The moment you get the complaint, you're going straight at their throat.
so this is where the law librarians really helped me out, because I thought that I would have to file a motion separately for counterclaims, but they told me, according to the procedures, I can actually include them in my response to the lawsuit. So this
Precisely.
is very convenient, and it's the first document I filed, right? So it is from the get-go,
Precisely. Perfect.
like you talked about, and then that puts them in the hot seat.
Yep.
So I thought it might be helpful to list off the counterclaims that I made, because I think these are relevant even if you're filing the suit, right? Because they mess things up in a number of ways. Now, the first one was frivolous litigation, because now that you can only file as a defendant, right? But basically, I said that their claim is based on evidence that's not factual, because they say there is no payment when there is a payment, right? So frivolous litigation, and what that allows you to do is ask for damages, damages for your fees. In other words, if you paid a lawyer, or for your own time, that you can get in that case as a defendant. And they, by the way, they asked for court costs in their initial complaint. So they want to sue me, and they want me to pay for the expense of suing me. So I'm saying you sued me frivolously, based on things that are not factual.
Yeah.
And so you actually have to pay my court costs. Now, the other three that I filed could be causes of action in your complaint as a plaintiff. And so obviously, we've been talking a lot about breach of contract. And the fraud that you mentioned is part of that, right? Because they misrepresented themselves fraudulently in the contract, and then they did not fulfill their obligations of accepting payment for the contract. Then there's a breach of fiduciary duty, because when you negotiate or endorse a negotiable instrument, and then you deliver it to the responsible party, they have a fiduciary duty to you based on that instrument, if you have a certain status on the instrument, which is known as the holder, or the holder in due course. So now this is where you have to learn some more about negotiable instruments. But essentially, they sent it to you for you to do something with, and that makes you the holder, or like kind of like the owner of that instrument. And then when you send it to them and say, here, do this with the instrument, and you've done it according to the law, they have a duty to you to carry that out, a fiduciary duty. And if they don't do that, they violate it. So,
And the beauty of what Dr. Kaufman just said too, by the way, is that's the actual legal definition of the word payment. The actual legal definition of the word payment is performance. Payment and performance mean the same thing. So when they send you this paper, you're supposed to do something with the paper. You do something with the paper and you send it back. That action of doing something with the paper and sending it back legally is defined as a payment, and it's actually legally defined as a payment for US dollars. And that's the part that literally, I've talked to massive private banking professionals, and there's even a guy here who lives in my building who is at Chase Bank over here. And he even told me, he's like, yeah, I've been hearing about some of this stuff. I didn't know you did this. Like, I'm actually very curious in some of this stuff, because it's just like, we never taught any of this stuff in the banking. And I said, oh, come over, man. I'll teach you everything. I sent him some videos and stuff. So yeah, it's it all. So what banking is, just to clear this up, because I think this is also really important to talk about, just really, really quick. Banking is a massive, humongous cloud of completely unnecessary complexity that was developed on purpose so that no one would understand it. Okay. But in real, honest to God truth, it's just a few pieces of information. Like, that's it. It's literally just, they give you paper, you sign the paper in a certain way, you give it back, and that's it. You're done. Literally, like, if you want to go to the ultimate simplicity as to how it really works, that's how it really works. And you think, oh, it's all so complicated. Oh, it's also this. When you start to realize this whole thing, you start to go down this rabbit hole, you see all this information like this, right? And then you start to dig and dig and dig, and you're like, oh, this is junk, you throw this out. All this is junk, you throw this out. This is junk. And you wind up with just a bunch of dumpsters. And all that's left is just like a few pieces of information. That's it. And that's the beauty of it, because it's designed that way on purpose so that no one can understand it. That's the only defense they have.
Yes, and they of course, create lots of terms that are redundant, and the way that they write the language in the law is often, they'll have, several clauses, and then connecting a subject and a predicate, with 4 commas in between, right? So it's tricky. You have to kind of learn the technique, and you have to sit there always with the law dictionary, because even simple words like, here, I'll give you one, you probably know this already, but the word at in a law dictionary
Yeah.
means near. So, like, for example, attorney at law means an attorney near the law,
Yeah.
as opposed to like an attorney in fact, right? Which means that they are the fact attorney, right? So, this is, really important. You would easily miss something like that. And that's how we know that payment actually means performance. It doesn't mean handing Federal Reserve notes to someone, and it doesn't mean handing gold to someone,
Yeah.
right? It means performing.
Yeah. So performance. So people think they have to go out and work to get Federal Reserve notes and then pay with Federal Reserve notes to discharge quote debt. But what we're learning, and the secondary option, and the, in my opinion, preferable option, is to simply perform. When you perform, you don't need Federal Reserve notes, and your debts are paid. The problem is
Right.
that no
That is,
one knows that. Even the bank doesn't know that.
well, someone
And
at the
that's
bank
the
knows
issue.
it. Someone
Someone
at
at
the
the
bank
bank
knows
knows
it.
it, but this is where this movement is currently located. This movement is currently located at. We know how this all works. We've got it all down. We deliver what we need to do. We perform, but they say we haven't performed. They say it's not a payment. They say it's not U.S. dollars, and you get on the phone with them, and they think you're fucking crazy. So what other options do we have? We have litigation. I mean, look, and I always tell everybody the same thing. If you have a better idea, I'm all ears, because I don't know of anything better than I don't know of any other option we have except litigation. Litigation is, you are forced to sit down and have a conversation with me about how this really works. And if I prove that it really does work this way, which is very easy, by the way, then you're going to now accept my performance that you didn't accept before, and you're going to pay me for wasting my time. That's what litigation is.
And that's, by the way, all these things, right? You can simply, in your interrogatory, ask the other side,
Yes.
what is your definition of payment?
Bro, I'll
Where
tell you, I'll tell
what's the
you,
source of that, right?
I'll tell you guys, I'll tell the audience. Let's say there was a lawsuit for $50 million, and I had to choose between the $50 million or just getting my questions answered. Fuck the 50 million, bro. You can keep it. I don't even want it. Don't even
Well,
show
that's
it to
like
me.
asking for a wish to have
I
more
want,
wishes, right?
bro, I want the questions answered. I'll pay. Keep, you know what? Hookers and blow. Go take the 50 million, do whatever you want. Send me photos of how much fun you have with the 50 million. I want answers to these questions, because answers to these questions are make the 50 million look like a ham sandwich from Costco. Literally. That's how I think of this information, because dude, if I find out how the Federal Reserve window works, who's the person who does the swap, do they know how this works? I want to see the forms that are submitted. I want to see the endorsements that are submitted. Why are they submitted that way? Blah, blah, blah. You can literally print your own money forever. When you realize how this really works and you get down to the actual facts and you start to ask these kind of questions, it's infinite money for real. And it's infinite money from like 3 different sources. You can swap shit. You can do credit card swap. You got infinite money literally all around you. You can go on private jets. You can buy 10 private jets, 10 mansions. I could buy 15. I could buy the whole Hollywood Hills, all of it. So 50 million, I don't want 50 million. That's disgusting. Don't even show that to me. I want the information, because if you get the information, I'll drop the whole lawsuit, bro. You just give me the information, I'll drop everything. I'll cut you loose. I just want that info. I want it so freaking bad. So that's kind of why, like, I love this idea. I love litigation, because I'm literally going to tell these people, like, you give me all this information and you hook me up and you show me how this works and you help me enter into this zone, I'll drop this lawsuit. You won't pay me a penny. And that's also very powerful. Do you see?
You're right. And that's why we have to, be able to exchange this kind of information about these suits, right? I'm really hopeful that I don't have to have a non-disclosure, right? I want to get as much out on the table.
Well, I've done a lot of research. They always make that part of the deal.
Right. But I can, talk about everything up to that point, as long as I don't give away identifying information, and, still be covered, because, we want to know what's going to be effective. Right. Yeah. And that if I know that, well, we settled it, that means that I came out on top, because
yeah.
otherwise it's going to trial.
Well, the settlement, the way settlement works just so you know, from all the research I've done, there's a couple things to say about this that I've never said, because this is all like I'm learning all this, right? First and foremost, a settlement is not really them admitting guilt to anything.
No, no, absolutely not.
So it's kind of a weird, complex thing where you're not saying like, I won, you kind of won, but you kind of didn't. Sort of. It's kind of a weird thing. You wouldn't say that they
Well,
admitted
Brandon,
guilt.
I would say that it is a win, but
No, it is
what's happened
obviously,
is
yeah.
like that the other side is saving face, right? Because
Yes.
they,
Yes.
even if they might even be able to be victorious in the end, but it would cost them too much.
Yes, that's true.
Right.
Yeah.
You've too
Yeah.
difficult of an adversary, or the PR angle is too difficult, right?
Yeah. Yeah.
So it doesn't, but it doesn't tell you what the law rules, right?
Yeah.
Because they're conceding. So all you can do is up to that point, right? You know, okay, were there any motions that were ruled upon? Was there evidence allowed to be admitted? Like what happened right before they decided to settle? What did you do something? Because if you did, right, then that's the thing that made them settle, right? So I think we can still learn quite a bit from the experience, even if in the end, right, there's not a complete adjudication. And I think the only time you'd end up going all the way to a verdict in a case like this is if you mess up in some big way. So either you're completely ignorant and you get made a fool of on a deposition or testimony,
Yeah.
or you submit arguments or documents that could be fraudulent, or right, like, or if you try to use a sovereign citizen argument or talk
Oh
about the
God.
straw
Yeah.
man, that kind of stuff. Like anything you bring up, you have to be able to prove, right? So I wouldn't go in there and say, anything about the all caps name or my agency unless I can prove it. So I would use just evidence. I wouldn't come up with some story about or I wouldn't mention the Cesta KV Act of 1666
Yeah, this is a
in court.
conversation that I've played in my head a million times, because I'm moving in this direction. So I project, right? And I think of myself in a courtroom, many hours a day, honestly. And the truth is that, from my own research and my own idea and my own self-reflection, it's sort of like, uh it's a very simple conversation. It's if you admit that this thing on this piece of paper is me as the human man, then that means that this is now a common law court, and I have all the rights of a natural human, of a real man. Is that where you want this to go? And they're going to say absolutely not. Okay, fine. So we're actually in agreement that, you know what I mean? Like you can even pitch it in that direction, the opposite direction, where it's like, look, if you want to say that this is me, I'm actually cool with it, because that means that I have all my human rights, and we're going to go to an Article 3 court, and it means all these horrible things that are just going to absolutely decimate you in like 10 seconds. So if you want to say that's me, I'm actually cool with it. You know what I mean? It actually benefits you and it benefits me to say that this thing is an ins legis. Which the law obviously proves that out as well, but it's just kind of convoluted. But if you want to cut through all the convoluted shit, just say, hey, look, if you want to say this is me, dude, I'm actually down. I actually don't have a disagreement with that, because now I reserve all my rights, and now I'm a human, and now you're really in trouble. You see the difference? So
I don't think the court would allow that because
they would never allow that. They would never allow that,
yeah,
because
because
they would
say
lose
you don't.
jurisdiction like this. Boom, jurisdiction's gone.
They would also say that because the way you're talking about it, right, is that you'd be basically claiming ownership over the name, but they'll say that you're not the owner, and
Exactly.
that has been adjudicated in a courtroom before.
But I'm just saying, like I'm not going to be the one on the defensive. But basically, like what I've realized in the past few weeks is I'm going to be on the offensive the whole time. If you
Well,
come
that's
after
because
me,
you're not the party who's wrong.
that's what I mean, though. That's what I mean, though. It's like it all comes down to what's in your head, right? So it's like, you think I'm going to be on the defensive and be like, I'm going to prove this and prove that? Like, no. Look, you want to say that's me, bro? I'm all about it. You want to see that it's a conditional acceptance too, which is what I teach in my course and stuff like that. It's, hey, look, you think that's me? You want to say that's me? I'm actually down, bro. But these are going to be This is going to be what's going to happen if you agree to that. And the judge is going to run in from fucking center field and be like, no. But I'm just saying, like, if you, between me and the prosecution or me and the defendant, like, hey, you want to say that? I'm actually down, bro. But I want you to know, if we do that and that's what you think it is, it's blah, 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 all this stuff. Like, and I'm going to sit there like this, like, hey, you know what I mean? If that's what you think it is, like, dude, let's go, bro. Let's go. You know what I mean? It all depends on many different factors too. But it's just there's a certain, we had this conversation over the phone where it's like there's a certain point where it's no longer about the information. It becomes a spiritual, emotional, honorable, intention based battle where it's just like you have a bunch of facts, and it gets up to a certain point where it's just like who has more confidence, who knows what they're saying more, who has more passion, who has more devotion, who has more intention in what it is that they believe and they're saying. And there hits a certain point, I believe, that that's where the battle really occurs. Because you and I can both agree, and anyone who understands this information anywhere close to what we're talking about in this podcast, that the facts are all horseshit. It's all horseshit. I mean, negotiable instruments and all this it's literally all just a joke. None of it even exists. All a joke.
It's just a game. It's a Monopoly game, the very sophisticated one, right?
Yeah. So for me, there it's like logic, and then above that, it's just like, bro, like I will spiritually burn this whole city to the ground for what I know to believe to be true, just, correct. And if you think you're going to stop me and you think you're going to sway me and you think I'm not going to get this done, you're delusional. Never going to happen.
You know, having this belief in yourself and confidence is vital because, you know, there are going to be a lot of attempts, right, to get you to doubt yourself, to second guess, or to induce fear as
Oh
well.
God, so common,
Right?
yes.
Because, oh, you're gonna, you know, owe debt. We're gonna garnish your wages, lean your bank account, put you in debtor's prison, all these kind of things. So you have to be confident in the, you know, in your opinion of the information, such that you are emotionally grounded,
Yes.
right, and have this composure because, and you are in the right, right. I have to actively remind myself of this thing because when I do, you know, check the mailbox, right, and I see there's another, you know, letter threatening foreclosure or, you know, some other thing like that, right? It's like, well, gosh, you could, but then I go back and sit in my house and I realize everything is just fine. And this is all just part of the game of sending paper around. And eventually will, you know, justice will come to be, right? And then, you know, they won't send me threatening paper anymore. They'll just send me the regular paper, right? So you have to be kind of in that state of mind in order to go through this, right? So if you're afraid of your own shadow, then this is not the right path for you to go right now, perhaps.
Well, I was terrified for a long time. I was terrified for a long time. I mean, all those letters and all that stuff. I mean, it just scared the fuck out of me. But I just said, you know, I know this is right. I know this is true. And I just have to, I don't know, just keep going. You know, and then once you get through that first run, especially like the first time you do any of this stuff, you know, you come out the other end and then it's just like way easier the next time. And then it's way easier the next time. And right. it's just like anything else. It's like hitting on girls at a bar. It's just like getting a new job or getting a job interview. It's just like moving to a new city. It's all the same shit. It's just life. We're talking about life here. We're not talking about some crazy esoteric, totally. Everyone listening to this has experienced what we're talking about. It's just that it's in a new zone. It's a new area, but it's relative to everything you've ever experienced in your entire life. It's the same shit. It really is.
That's right. You can always, lose things, right? Everything you do that's worthwhile is taking a risk. You drive your car, you could run into a moose and lose your life at any time, right? And
Hmm.
this, you might lose possessions. You might have repo men following you around, whatever. But any material object can always be replaced,
Hmm.
right? And in the end, right, we will be able to enjoy the full benefits that we're supposed to if we, keep focused on the truth and, don't give in to that kind of fear and intimidation. So, Brandon, I feel like
Exactly.
we've been going for a couple hours and we've covered quite a lot of ground, right?
Yeah,
And
this is going to be cool for my audience because we're talking about a lot of things in this show that I haven't really talked about yet because I'm a little careful in what I talk about. I try to get into it, study it for a long time, at least kind of dip my fingers into it, and then I kind of start talking about it. There's a huge delay between when I start researching something and when I start talking about it. Um, and a lot of this is stuff that everyone's asking me all the time that I just refuse to talk about up until pretty much this point. I think a lot of it comes down to how impressive your documentation is. To be honest with you, it's a I can tell you've really put a lot of effort and time and into this, and it's just really it's really impressive. Like to the point where I would go so far as to say, anybody that thinks that I'm some kind of professional in this area, I would say that I would consider you like my equal, honestly, truly, in a lot of ways, because the documentation and how much you've spent on this and how far you've gone down the rabbit hole on this and how much you've if anything else that you teach and anything else that you talk about involving natural health or anything else is anywhere close to as well researched and documented as what I've seen you do with this, it's very impressive, very very impressive.
Well, listen, when I'm passionate about something, I, can't, I get obsessed almost because I just want to learn. I'm thirsty for knowledge and understanding, and it's just something that's driven me in my life, and especially when it could result in some form of achievement of justice. And this is really right in that area, as is healthcare, right? So they've both been things that I've been passionate about. And yes, you're right. I just dive in like you do, read and listen to everything I can find. And then once I got that threshold of confidence, I started actually doing these things. And yeah, I didn't really have success yet fully, right? Some minor successes, but I still persist because I know, right, that this is really the way things work. I
Hmm.
just don't have quite all the answers because of that complexity that's put in here. I believe purposely to make it really, really difficult
Oh God,
for
yes.
you to, fully realize, your capabilities and how you're supposed to engage with this system. So, I'm very honored by your compliments. And but we'll see. What does the other side think of what I've written? What is the judge going to think of it when a judge gets assigned? And that will be the real test. And I will be sharing at least parts of these documents to help other people see, how I write the reasoning related to some of these things. And it's really quite simple. I mean, just make sure everything's included, but I find the law source and I look up what it takes to make that argument, and then I just put in some basic elements, um, you know, to refer to that. And, I'm lucky because my experience in the past involved being an expert witness and
Yes.
writing documents for the court and reading court documents. And so that gave me, to sit down and write a legal document. I have experience with that already, even if I haven't litigated. So, but it's definitely, I'm at creative writing or writing something that's engaging to readers. I'm terrible at, right? I can write scientific writing, legal writing, like stuff that's cut and dry,
That's
analytical.
hilarious.
So in a way, I feel always feel like my writing is could be a lot better. But this is not fancy writing, right? This is basically write it clear, make a clear argument. Use logic, right? Set up the thing. First A happened, then B happened. A plus B equals C. That's all you have to do in
It's a
document.
little depressing in that way. Yeah, it is very, because I'm the opposite, I guess, of you. I'm almost like a I'd almost go so far as say I'm more like a woman. I want to get into all the feelings. I want you to cry and laugh,
See,
and at
that's
the
what
end
you're
you
going to be
fall in
great
love,
at a trial, because you
Yeah.
get up there, you do that for your opening statement, right? And
Yeah.
then
Yeah.
you'll
Yeah.
engage them,
Yeah.
and that'll be very very useful.
But I can see in general action, this is definitely more of a male demographic area up until trial. And then I would say, yeah, it becomes more of a 50-50, or maybe even like a 60-40 on the female end of the spectrum. But um
There
it's a
are some
very
women who have taken this quite far. In fact, I studied with a woman to learn the equity process, Rebecca Rodriguez, and we have done a discussion like this as well. So, this isn't a barrier, certainly for anyone, but you do have to draw on your masculine energy, because
yeah.
the a legal matter is adversarial by definition,
Yes.
right? So
Yes.
you're now
It's literally war. Yes.
so you have to be prepared to engage in that,
Hmm.
and not ingratiate yourself. But there's advantages also to being a woman in this arena as well, because you may be able to weaken a man just through your
No,
woman
very true. So true.
power. So
Yeah.
it's approachable. Anyone of either gender, right? Of either of the two genders, can certainly
What about
approach
Zerzims,
this
huh?
space.
When you look at his reaction, no Zerzims allowed. Get the levity in there a little bit. You
Yeah,
know what
we've got to have a
I
little fun with this material.
mean? Zerzims don't have any rights, which is very sad. It's all just a big ploy. It's the they thems and the Zerzims. You're not a man or a woman anymore if you're one of those things. So you don't have any rights. So the whole thing is a campaign to strip you of your rights. And I like to communicate it as that, because what it does is it doesn't really make those individuals who may think that way wrong necessarily. It's a warning. I give it as a warning. It's full disclosure. They deserve full disclosure. And the full disclosure is, if you want to do that, you are relinquishing your rights as a man or a woman. And if you want to continue down that path, you deserve to know that. And if you want to do that after fully realizing that of what you were about to do, that's your choice. That's kind of how I pitch it. Because otherwise you end up getting deplatformed or whatever. I don't pitch it specifically to not get deplatformed. That's really how I think of it.
Yeah, well, many of the sort of cultural arguments, let's say, that are put forth that would seem to create more fairness, more people getting along with each other as such, right? And they sound really good, and the language that they use makes it very attractive, right? That we can all love each other and live super happy and free lives. But those things, in actuality, are the exact opposite of that.
Yeah.
They are that's the way that they sell it to us. But if you look beneath the surface at the actual policies, at the actual laws, you'll see that it's bringing about everything but those desirable characteristics. And the truth is that if we want to have harmony and tolerance and acceptance and teamwork and collaboration and solidarity, we have to each work personally on those things ourselves. Those are, we can't force everyone to behave the way that we would like them to behave. Of course, we have to kind of not allow them to infringe upon our rights directly, right? So we have to have some kind of rule of law. But really, if we want to make a great nation, a great world, a great home, a great congregation, a great friendship, a great community, it's always up to the members of those entities through their own action and effort. That's the only way to create those things and to relate with each other in those godly ways.
Yeah. Yeah, and it's so interesting because even a lot of these groups and a lot of these things that you're seeing pop up now, what a lot of people don't realize is under 50 USC section 842, it actually states that anyone who is who prescribes to or is a successor to or a subsidiary organization to the Communist Party basically does not have any rights in America. So you also have to realize too is that there's a lot of trickery that's tricking people, especially young people, into joining communist related activities, we shall say. And again, it's all about deterioration of rights because the Zerzims and the they thems and all that, they've just burned all their rights in a trash can. And all the communist people who get tricked into communistic behaviors or communistic groups, they've just burned all their rights straight in the dumpster, straight out of the United States Code. So it's one of those things where it's a weird world we live in where there's a lot of trickery trying to get you to believe as though you are doing something beautiful when in fact you are destroying yourself. And then what happens is the mind, as you know, has a tendency to defend that of which someone has decided upon, and the more a person has invested in that of which they have decided upon, the larger the fortress is that will defend those particular. So the way that the whole system is built in these communist factions is they get a person to join or perform in sort of some sort of communist faction, and then they have them contribute and contribute and contribute and contribute, and the more they contribute, then the more invested they are. The more invested they are, then the more willing they are to defend that of which they have been invested in. So what it is it's very sad because then you have someone who joins something that appears on the surface to be very very good and very very wonderful, and then 6 months later now they've entirely encased themselves inside of this thing of which they will almost die for, and they can't get out because they don't understand that their own mind they've let it in, and then now they defended it, and then now they're a prisoner of it,
Right.
and that's the very very depressing. I try not to do too much direct uh uh degradation toward those people because I feel like I have a little bit of empathy toward that situation myself. Not that I excuse the behavior necessarily, but it's understand your enemy. That's what the Sun Tzu law number one: know thy enemy. And that's kind of the entire basis of my entire platform. And I try so hard to do that.
There
So
were such sophisticated methods of mass, manipulation, right? The whole public relations industry was sort of founded upon that. We have, psychologists talking about this, things like mass formation, right? Which is kind of what you just described, how it can happen on a large scale. And, identity politics is another way to refer to
yes,
that, right?
yes,
So,
yes, yes.
so we're, for us to take on this, like we've had to first overcome all of that and realize, that all is not really what's going on. That's not the real truth. And Brandon, I want to wrap it up, but
Yeah,
this is
sure, totally. We
this
could
has
probably
been
talk all night,
great.
huh?
Where tell people where to find you again, and definitely if you haven't already, sign up for his Contract Killer course. That's the core material. You'll get to know Brandon and be introduced to all these topics, and it's a great springboard for further study and to head towards litigation, right? Which we talked about tonight.
So, like I said, it's a Beavis and Butthead slash Jerry Springer show, but the clean version is don'tbeaslave.com, or you can go to brandonjoewilliams.com, but it will redirect you
Now,
to a
I'm going to
different
put your
website.
main web address in the show notes below, and I appreciate you not using such colorful language here. But so let me say it. It's onestupidfuck.com. All right. There you go. I'm no longer a virgin.
Yeah,
Um,
perfect.
yeah, it's worth checking out, and the website has extensive resources, including all the statutes that we mentioned tonight. I guarantee are listed there in reference, and the language of many of them is there as well. So it's a great resource that you should not pass up, and everything is 100% free unless you want to buy some pickle paraphernalia.
That is so true. That is so true.
All right,
Thank
Brandon,
you. I
it's
appreciate this
really
so
been a
much.
pleasure.
I would love to get a copy of this for my audience. This has been fantastic. It's definitely one of the most advanced discussions I've ever had, if not literally the most advanced discussion I've ever had. So thank you very much.
Good. I'm looking forward to the comments. All right, you take care, everyone. We'll see you next time.